Folks, we're back. This is Steve Sanson, Stephanie Phillips with another episode of Veterans in Politics. Today we have Gwynneth Smith, candidate for Clark County District Court Judge, Family Division, folks, Department D as in Delta. But before we get to Ms. Smith, Ms. Phillips.
Thanks for joining us, everybody, and thank you to our sponsors. We have Dr. Ari Nagy. He is running for Congressional District 3. His website is nagyforcongress.com, and that's F-O-R, nagyforcongress.com. Jump on his site and see what his platform is all about. We also have Henderson's mayor, Michelle Romero. She's running for re-election. Her website is votemichelleromero.com, votemichelleromero.com. And we also have Cody K. Whipple. He is running for Congressional District 4. His website is codykforcongress.com, and that's the number 4, codykforcongress.com. Jump on his website and see what his platform is about. Don't forget to grab your copy of Steve's book, How to Navigate Nevada's Family Court System. If you are a litigant and you don't have an attorney and you can't afford one, this is a self-help book, and this will help you navigate that system. You can get a copy on Amazon. It is $14.99. Also, we have a merch store. It's vipimerch.com, vipimerch.com. Jump on there and see all the fun stuff we have on there for you. And also don't forget to grab your tickets to our Valentine's Ball, which is February 7th of 2026. You can get on our Facebook pages and the link is there to grab tickets. We have early bird tickets on sale to the end of the year at a discounted price. And then after that, the prices go up. So don't forget to do that. And also for my rant, I will make it short, but as everybody knows, the government now is shut down and only certain people are getting paid. I understand that come October 15th, now the military won't get paid after that. This is all because Chuck Schumer and company wants American tax dollars to go towards illegal aliens' health care. This is why the Republicans refuse to deal with them and this bill. There was a clean bill. Schumer comes in and shoves $1.2 trillion, I believe the amount is, down the American taxpayer's throat to pay for illegal aliens' health care. That is absolutely ridiculous. So the Democrats in the Senate, you guys need to get it together. We should not be on the hook for paying illegals health care. Oh, and one more thing, which I thought this was absolutely fabulous. At least somebody has some sense here. This guy, what's his name? Hold on. Congressman Ralph Norman. He filed a bill to end congressional paychecks during a government shutdown. Amen to that. And no back pay. Okay. So when it starts hitting your pocketbook, maybe you guys will think differently. So, and there was a whole bunch more in there, which, hoorah, Mr. whatever, what was his name? I just forgot. That guy. Awesome. Great job.
That'll speed things up now, wouldn't it?
Sure will, won't it?
As soon as it start affecting your purse strings, then you want to put a rush on it.
None of them should get paid either. None of them. In fact, today should stop all their pay.
Yeah.
Until they come to an agreement, because this is hurting the American people. Okay.
Well, thank you, Ms. Phillips. Ms. Smith.
Hi.
Thank you for being here.
Thank you for having me. I appreciate it.
Could you give us a bio, please?
Yeah. How far back do you want me to
The
start?
day of birth.
Well, I won't go quite that far back, but I'll start out. I grew up in a small town south of Boston called Scituate.
I don't get the accent though.
I know I'll go on with my story. I've lived a lot of places, so I kind of grew out of it a little bit. Lived there until I was 16. And then we actually relocated overseas for my dad's job. So I did
What did Dad do?
He worked in publishing, medical publishing at the time. So we moved over there. I finished high school at the American School of The Hague, graduated, and came back to the Boston area for college. I went to Harvard for college.
Harvard? Where'd you get the Harvard money from?
Lots of saving. Lots of saving. Graduated with a degree in psychology with honors. And you'll see as I kind of go through my story, the psychology side of what I've done is kind of a big...
That would help with the family court.
Yeah. So I finished with a degree in psychology. Like a lot of people, when you're 21 or 22, you don't know exactly what you want to do. I thought I want to go somewhere new and, see a different part of the world. So I went to an international job fair. I got a job working for Procter and Gamble in Belgium, Brussels, Belgium. So I moved to Brussels when I was 21, lived and worked there for 2 years, met my husband. So we got married over there. We've been married for Hank.
Want to give him a shout out?
Hi, Hank. Married for 22 years and decided after a couple of years in the business world that kind of wasn't my long-term plan.
Kiddos?
I have a daughter.
Okay.
Yeah, I have a daughter, 10-year-old daughter. So decided I wanted to go back to school and I really wanted to go into a helping profession. So I wanted to go on and continue with psychology. So Hank and I moved to the San Francisco Bay Area and I enrolled for a joint degree in psychology and law. So I have a PhD in clinical psychology and I have a law degree. And I did those simultaneously starting in 2003.
Oh, wow.
Yeah, it was busy. I look back, now that I'm older, I look back and I'm like, I'm glad you did that when you had a lot of energy and you were young because it was pretty busy. So was working on the PhD. I took a lot of my law classes at night. I went to Golden Gate University in San Francisco for my law degree and did the PhD at Palo Alto University. And for the last 2.5 years, so I graduated law school in 2007, passed the California bar, but had to continue with the PhD. And so the last couple of years that you do that, you have to do a pre-doctoral and postdoctoral internship. And so I was at the medical school at the University of San Francisco, University of California, San Francisco. And this is kind of what has ultimately pulled me into the career that I'm in now. I was working with kids and families for those 2 years, a lot of whom who had post-traumatic stress disorder, and almost all of whom were involved in the court system in one way or another. So I had a lot of adult clients who were receiving services because they were victims of violent crime. I was part of a team that responded to the emergency room when sexual assault victims came in for services at the emergency room. And then the other half of what I did was working with kids and families, parents, caregivers who were in the child welfare system. So I had a lot of experience working with kids who were victims of abuse or neglect, but also parents who were working to reunify with their kids, doing services to address, issues that they were trying to get under control. So I came to know in a really kind of human way all of these individuals who were working through their court cases. And I saw the huge impact that the decisions that were being made in court were having on my patients. And so over the course of those couple of years, I had thought I was going to be a psychologist, kind of with a legal background, maybe practice forensic psychology. And by the time I came to the end of those 2 years, I was like, no, I want to be where these decisions are being made. Like I have something I can offer there. And so I decided that I was going to go into law and use my psych background in the legal arena. At the kind of right at the time I was finishing all of that up, my husband got a job offer here in Vegas. We moved. This was in 2012. And I was right at the point in my career where I had to make this choice, what direction I was going to go. I applied to the DA's office here, and I was lucky I got hired, and I've been there ever since. So going on 13 years, started in the criminal division, first in appeals, then I was a criminal deputy for a year. I knew I wanted to work in juvenile court. That's where I thought I could have the most impact. So I advocated to transfer to the juvenile division of the DA's office, where I've been since 2014. So,
Wow.
Very
and now I'm here.
Mm-hmm.
I like that. Actually, I like
Thank you.
people have the psychology background being in family.
I use it every day, and I'm not saying I'm solving any clinical problems,
Right.
but I'm saying the perspective you have as someone who has experience treating people, you bring that perspective when you're working with families in the family court system for sure.
Well, how do you plan to transition from the mindset of an advocate for the state to the impartial role of a judge?
It's really critical. It's a really, really critical transition that you have to make. I mean, I think the first part of it is you just have to be really conscious of it every day. I've been in my role at the DA's office, as I said, for going on 13 years. And so you really have to step out of that because it's a completely different role that you're going to take on as a judge. You have to look at every case impartially. You have to look at every case fairly. You have to weigh the interests of all of the parties. It's something I think I'm capable of doing. Even though I'm a DA with a particular position on all of these cases, kind of from what I've already described, I do think about the interests that the parents have in the case, not just from a legal perspective, but I'm also thinking about, what are they presenting with? What do they need help with? I actually view on child welfare cases, it's really, really important to understand the parents and get them the help that they need so that they can reunify with their kids wherever possible. So it's going to be taking that perspective and then shifting it to that of an impartial judge.
So we've been vetting candidates for the past, year now? Almost. And a lot of attorneys want to stay away from family court at all costs. They said, one said, I wouldn't touch that with a 10-foot pole. Why would you want to dive into what people are running away from?
Because it's so important. It's so important. Really, when I got hired at the DA's office, as I said, I was in the criminal division. And when I said, no, please transfer me to juvenile, there were some discussions around that. And I persisted and I advocated for it because to me, critical decisions for our community, critical decisions for our kids and our families are made in family court. Is it tough? Yeah, for sure. These are complicated cases with
very emotional,
highly emotional. You're making decisions to protect kids, but also about people's kids, and people feel understandably really emotional about that. I get it. But these decisions are so important, and it's so important to have, I think, really experienced, ethical, passionate people on the family court bench. If we can get these decisions as right as possible, you have the opportunity to try and impact lives that'll go forward for years.
So everything that you've been doing now, all that has been in criminal court only, right? None of it's been in family court, or some of it's been in
It's
family
in
court?
juvenile. So we're in the family court system. Yes.
Okay.
Yeah. So I practice mainly in front of the dependency judges. I also, a couple of years ago, was assigned to a specialized calendar that we call the dual ward calendar. And these are really complicated cases. These are kids in the foster care system who've also become involved in the delinquency system. So they're called dual ward because they're in both of those systems simultaneously. These are kids who typically have been through a whole lot of trauma. They've been in the system for
the ones that's been bouncing around from
typically
family to family.
They've had, they may have had multiple placements, some with family, some not with family. And then they become involved in the delinquency system. And so on that calendar, what we're really trying to do very hard is try and stabilize these kids so they don't go further down the route of delinquency. A lot of these kids also have some significant mental health challenges. So it's about identifying what do they need, what services do they need, how do we get access to that? If they need a specialized placement, how do we get access to that specialized placement? Fighting for kids to have access to that, right? Sometimes a child needs to be hospitalized for a period of time. Unfortunately, in our community, and this is a nationwide problem, it's not just a Las Vegas problem, mental health resources for our youth are scarce and accessing them is hard. And so that's a whole lot of work. I often think sometimes when I'm doing that, and every day I'm working very hard at that, I often think, gosh, I'm a lawyer, I'm a DA, I have access to court, I know how to art, and it's still so hard for me sometimes to get services that kids need. And it makes me think of families in the community and how hard it must be for your average family.
Before I turn you over to Ms. Phillips over there, she's salivating. Jesus, I forgot what I was going to say. Department D is a juvenile department. They deal with relocation, they deal with termination, and all that stuff. But the question that I want to ask you something about that too. But the question I wanted to ask before I turn you over to Ms. Phillips is that we had a judge that sat right there, Stephanie Charter. I don't know if you know her.
I do.
Okay. And she said that her strong suit was juvenile.
Mm-hmm.
And she was transferred out of the juvenile department to domestics, which I guess that was one of the deciding factor for her to resign.
Mm.
What happens if that happens to you? Because your strong suit sounds like it's juvenile. What happens if they turn you over to domestics? And domestics is what? Division of property, divorces, and all that. All that nonsense stuff, right?
Yeah. Well, I wouldn't call it nonsense stuff.
That's what some people would call it.
I take your point.
Versus the juvenile, they figured juvenile is more important than a simple divorce,
well,
right? Or a division of property.
I can kind of see both sides to it. There's one school of thought, and I can agree with it, that says if you have someone who's really experienced and talented in one area of law, why not exploit that?
Exactly.
And I really understand that. There's also another kind of philosophy, though, that says if you're on the family court bench and you're a family court judge, these judges may hear multiple different kinds of caseloads, and it makes sense to have judges have experience in multiple areas. I can see both sides to that. I will tell you, for me, juvenile law is my passion, and if I'm lucky to be put on a juvenile caseload, I'll be really grateful. I'm prepared to hear any docket that I'm assigned to, though. And beyond that, I do think, you can get good, important experience on a variety of different dockets. For example, if you hear juvenile dependency cases, all kinds of other issues come up in those cases and touch those cases. So our juvenile court judges, the dependency judges now, also hear the domestic child custody cases that may relate to a family that is assigned to them. So you've got to have that kind of experience. There may be guardianships that come up in a child welfare case. You've got to have that kind of experience. So I think there's a benefit to having a breadth of experience. If I'm lucky enough and I, find myself in a juvenile docket, ultimately I'll be really happy. But I'm prepared, to hear whatever family court caseload I'm assigned. And listen, every different category of cases that comes before the family court is important. There's kids and parents at the heart of all of those cases. And having people who are experienced and passionate and ethical, no matter what the docket is really important for our community.
How often do you see cases with kids where they have to be charged as adults because the crime was so bad?
So that's the minority of cases. I typically, as a dependency DA, as I was saying, I'm assigned to cases where kids may come under both court systems. Right now, the way that works is if it's a case where a child is going to be certified as an adult, it does not come to my docket. So I don't have direct experience with those cases. It does happen. There's other DAs in my office who address those cases. They're really serious cases, obviously. There's a lot of considerations on both sides. But I don't have personal experience with those cases.
So as a judge, we hear this all the time. A judge makes an order, regardless of what it is. A lot of times it's child support. It never gets paid. For years, it goes on and on. And I ask all the family court judges that come on here, how do you keep people, do you hold them accountable and make sure that they follow your orders? So these people that are not getting child support when they've been ordered to pay and they have the money to pay, what are you going to do in that situation, regardless of whatever that order is? How are you going to hold those litigants accountable?
So there's a couple of options that you have as a judge, specifically with orders that pertain to child support. So the first is there's actually a division of the DA's office, different division than I work in, that specializes in the enforcement of child support orders. There's a lot of really talented DAs that work down there. There's a whole mechanism where they will kind of take the case from the person who's needs the child support and is not receiving it, and will help enforce that for them.
How many DAs are in that department?
I should know that number and I don't. I want to say like 7 or 8 probably. And then there's a large team of investigators I know that works with them and other staff that support those. So that's one option, but that's not the full answer to your question, right? As a judge, if you're hearing a domestic case and you issue an order, you also have options available to you to enforce your orders. So contempt can be issued, right? And there is the possibility of issuing sanctions, either monetary sanctions or even jail time in certain circumstances. I will say that you always try and get compliance, I think, in advance of going to that final step, although that final step is available. I also think part of it is just, as a judge, running your courtroom in a way, conveying your orders in a way that a party knows that that is always on the table and is always possible if the order is not complied with. There's certain things that you have to go through in order to impose contempt, in order to show cause process. The party has to have notice. The party has to have the opportunity to cure the issue in advance of contempt being issued. If you do issue an order for contempt, there needs to be a purge clause in it so the party has the opportunity to cure it that way. So those are a number of different options. But I agree with you. I mean, I think that's one of the most important things in the court system, and the most important things that the judge can convey is the control of the courtroom, and also that their orders, when they're issued, are, to be obeyed.
So that department you're talking about at the DA's office, we have heard from multiple litigants. I was just with one today. Has not been paid a dime of child support, has written to them, called that department, no answer back. We have heard from other litigants that that department has done nothing to get these people to pay child support. Nothing on you. I'm just saying, Mr. DA, that department needs some help. They don't, these litigants go 6-7 years, some of them. This one today was over a year, I believe. Not one dime, and they have the ability to pay. That's not it. But sometimes that department, when you're given these resources and those people are supposed to help, and they're not even answering emails. That is, so these people, I think rather than the responsibility falling on that department, because the failure of communication back is probably going to fall more into your lap as a judge to be firm with these people and follow my orders. I'm giving you an order for a reason, because a lot of these are single moms. And these guys that have plenty of money and can pay and don't, and then the judges allow to go year after year after year without paying child support. That, to me, I don't know how any judge could look themselves in the mirror and think, I'm doing a great job, when they allow things like that to happen.
Yeah.
Also, as far as
question,
well, I just wanted to get her opinion. I wanted to see what her opinion of.
I agree with
was.
you. I know single moms who have raised their kids by themselves. Like, I know the real life impact of that, and I know the importance of, when there's a legal obligation for support, there's a reason why child support laws were enacted and exist, because parents have a responsibility to their kids. So I agree with you. And as I described, there's multiple mechanisms, but at the end of the day, if you're the judge on the case, that's your responsibility.
Can we keep going?
Yeah.
Okay. So some of these CPS where these cases where it's alleged that the parents have hurt their children, but there's medical issues going on with the kids, or it looked like abuse, but it's really not. There are hundreds and hundreds of pages. There's videos, there's medical reports, there's the reading is absolutely just incredible amount of reading that you would have to do to review for these cases. If you see a case like that where they're accused but innocent, they're fighting for their kids, would you read every single medical report? Would you take the time to review all the videos, everything that is supplied to you? And because you come from the DA's office, would you kind of defer to them as the authority? Or would you look at each of these parents in these cases on the defendant side and be like, maybe they are innocent? Is it automatic because you've seen so much and you have that experience? Would you just defer to the DA side?
Well, the short answer is no. When you're a judge, right? If and when I take the bench, I'm no longer a DA. And it's my obligation and my ethical obligation as a judge to look at all of the evidence and render the appropriate decision. So the short answer to your question is no, I wouldn't on either side ever defer to either side. To your question on would I read all of the documentation? So the first question is it would need to come into evidence. But yes, once it comes into evidence, I can assure you I am the kind of person and would be the kind of judge who would review in detail every single item that comes into evidence. If it's thousands of pages, it's thousands of pages, but that's your job. If you sign up to be a judge, that's your job. And listen, a lot of what I already do on a day-to-day basis, I'm reading hundreds of pages a day in any case when I'm preparing for my court calendar. So that's something that I'm used to. I described my educational background. I did a whole lot of reading for that. So, but absolutely, I think if you're a judge on something as serious as, a serious physical abuse case where it's alleged that a parent has hurt their child and their position is, no, I didn't, and here's the information why, it's absolutely your ethical obligation to consider every single piece of evidence very closely, whether it's testimony that's given in the courtroom, whether it's documentary evidence, whether it's medical evidence. That's the job you sign up to do.
What do you think of SB 432?
So I've reviewed it. As I don't practice in the child custody arena. And so SB 432 is specific to 125 in child custody. So that's not exactly my area, but I've reviewed it. I know the Falcone case. I think Falcone in particular is a really important case because it articulates, in that instance, for domestic cases, but I think there's ramifications beyond domestics, the importance of the presumption of open hearings. And there's a number of reasons why that's so incredibly important. The first is that our public needs to have faith in the judiciary and faith in the judicial process. And I think it's really hard to have faith in a system if there's not a level of transparency and access to that system. I think that's the first step in people feeling comfortable with something. The second is we're a state that elects judges. So there's this enormous responsibility put on the public, put on your average citizen to make choices about who's on the bench. And it's really difficult, I think, oftentimes for the general public to know. Right. No, it is. You're right. To know the ins and outs of all these candidates. I work in this area and have for over a decade. Every cycle, there's probably at least one or two departments where I don't, personally know who and I have to do my own research. And so if it's that hard for me, I think it's really hard for the members of the public. So the presumption of open access is really important. there's going to be instances, and Falcone also talks about this, where there's other competing interests of the parties, fundamental interests that the court is going to need to consider as well. You know, from my experience, two of the big ones that come to mind, I was assigned to the sex abuse cases for 4.5 years. So I've seen cases, I mean, you know, you can imagine where kids have suffered the most serious egregious abuse, sometimes for years, right? And they haven't been protected by the adults around them. And so the judge needs to weigh the harm that may come to the child, the continuing trauma that may come to the child if their information as they're trying to recover and put their lives back together becomes public. So the court needs to weigh that. I do what's called the mental health court calendar. So these are proceedings for kids who have in mental health crisis, they may be hospitalized. There's a specialized set of proceedings under 432B for that. So sometimes I'm working on cases with kids who are in the middle of a crisis, maybe suicidal, maybe self-harming. So that's another interest that the court needs to consider. And the court may determine that closure is appropriate in certain instances. However, the court's got to think about not only is there a fundamental interest there, but then the court is also required to think about narrowly tailoring any of those orders. So do you close a whole case? Or do you really just, maybe it's just a particular hearing, or maybe it's a portion of a particular hearing, or maybe it's particular documents in a particular hearing. Is there a way that it can be crafted, you know, so you're not identifying the child, you're not showing their face, you're not showing their name. So the court really needs to consider all of that under the constitutional considerations. And then Falcone says that the judge has to go through that step-by-step, really thorough analysis, make written findings. So that's, Falcone really changed 125 in that direction from saying that closure is something that can happen kind of summarily, where a party just asks for it or the judge decides it, to know the court has an obligation under the Constitution to go through all of these factors.
So how many bills have you testified for? Because I'm over here looking at a few.
Yes.
Like AB 148.
AB 148, yeah. So AB 148, I testified twice during the AB 148 process. And that was a bill through the court improvement program. So the court sponsored that. And it was essentially an updating of the statutes that are used under 432B. I was just describing mental health court and the proceedings that happen when a child has to be hospitalized. It was an updating of those statutes. So under 432B, if a child welfare agency, so a child in foster care, hospitalizes a child in their custody for psychiatric reasons, either because the child is in an immediate crisis, you have a child who's experiencing suicidality, they're self-harming, that's something called an acute mental health petition, or if there's a determination from doctors that they really need some longer-term treatment, so something that's like 3, 6, 9 months, that's a residential petition. There's a whole set of statutes that lay out safeguards and require a lot of court oversight for kids in hospitals. And I think that's appropriate. These are some of the most vulnerable kids in our system. At the highest levels of care, they need, close court oversight. And there's a mechanism under there where the child has the right to ask for a second opinion. So if the child disagrees with the initial recommendation, let's say for longer term treatment, they have the right to say, I disagree. A second opinion can occur for the child. And there's even a right to a contested hearing, where I, as the state, the burden is mine to show these are the circumstances, these are the recommendations. It rises to the level, judge, that, this child needs this treatment and there's no less restrictive way of making sure that they're safe.
How many bills have you testified for?
I
Because
believe
you went back again in 2023, right? You testified on another bill.
I don't believe I tested.
How many in total?
AB 148
Was that the only one?
that was the only one, and I testified twice. It was in
Okay.
one house of the legislature, and then it went to the other house.
And you
of
were in the
legislature.
DA's office at the time.
Correct.
How did that even transpire? You testifying on the bill?
So as I said, it was part of the court improvement program, and because of my background in mental health, they did. So the head of the juvenile division of our office, like, you know, the Supreme Court said, hey, this is a topic that we're looking at. Is there anyone in your office who might be a good fit for this? And so I was put forward, and I was happy to do it, and it was pretty meaningful. It's a statute that, you know, I utilize every day in my practice.
Did you do it in person or did you do it telephonically?
It was telephonically. Both of the times for those hearings, the actual hearing was happening up north. So I went down to I think it was the Grant Sawyer building here at the time. And
I'm going to want to pull that now
okay.
and take a watch of it.
Okay.
Because I'm reading what you said, and I find it very, very interesting what you're saying. How come you didn't run for a legislative position like Assembly, State Senate, maybe even Lieutenant Governor? Because, you know, he's a president of the State Senate.
Oh, really?
Yeah.
I didn't know that.
Attorney General.
Lots of choices.
You know, what it all
Why
goes back
family?
to.
Why not civil criminal?
Because
your background.
And I know I said this before, I genuinely believe these are some of the most important cases that come before our system. And it's an opportunity for the system and the court system and for professionals to really make a big difference in kids' lives and families' lives. And that's what motivates me. So for me, it's a genuine passion for juvenile law and for being in family court.
Okay, so I'm going to switch gears a little bit.
Okay.
What's your view on judges allowing attorneys to draft orders, and how would you ensure that those orders reflect what was actually decided and said in court?
Well, the first step is that when you're the judge and you're in court and you're issuing the order, obviously you have a clerk who's taking the minutes, that making a record of the hearing, but also, I just know myself, I would be taking my own notes about what I ordered. I would be keeping my own record specifically of what I ordered. Certainly, if you have if something's decided and you order it and you can, you know, tell the prevailing party, draft the order, send it to the other party for review. If there's a conflict, send it to me and I'll be the final arbiter. But I would be keeping very close track myself of the orders that were issued, and I would be reviewing every single order that I sign.
So what happens if I'm an attorney, I'm in your courtroom, and I look back there and I see this Stephanie Phillips in the back, court observer, and I don't want her there, and I'm going to say, Your Honor, could we close this hearing? What are you going to say to me? I'm gonna apply the law is what I'm gonna do, What does the
right?
law say
And
concerning
so if it's a 125 hearing, these are presumptively open hearings unless we have those and then the court has to go through a whole analysis in order to close the hearing. And you cannot just summarily close, as I said, just because one party or the other says, I want this hearing. You have to go through a whole long detailed analysis. You have to really weigh, there may be legitimate other factors on the other side that need to be weighed, but you have to make specific factual findings
Ahead
on
of
the
time,
record.
not
correct.
All of a sudden I look around and I see Stephanie Phillips back there, court observer, and I don't want her in here and I want to kick her out, me being an attorney.
Hasn't that happened?
Oh, that happened
One
several
of
times.
our friends down there.
And I'm talking from experience, and I've showed up in Judge Tootin's courtroom many a times, and he let me put it on the record how I feel about it, that it's unconstitutional.
Okay.
This is a public courtroom. You're getting paid by public tax dollars. In fact, everybody's here getting paid by public tax dollars. Bailiff, JEA, the lights, the janitor, except for me. So he had me put it on record many of times. In his courtroom, and I thought he was very decent to do that.
Yeah.
But 75%, I think the numbers went to 75% of litigants are pro se. How are you going to deal with that?
So in domestic cases, you're right. In dependency and delinquency cases, typically all of those parties are represented. So that's a different story. But, as we were saying, I could very well be assigned to a domestic docket. And the vast majority of litigants, as you said at this point, are self-represented. Judges cannot be in the position of giving either party legal advice. But what I do think judges can do is be very clear and compassionate and methodical in describing the process that the court is going through so that people are able to understand what's happening. I think for a lot of self-represented litigants who go into court on these issues that are hugely important to them, right? Hugely emotional issues, decisions are being made about people's kids. And I sometimes think they must leave court and go, what just happened, right? And so I think the court has a responsibility to be very clear and methodical and direct people to resources wherever they are. There's a very good self-help center that the court can direct folks to. There are pro bono attorneys who will assist in answering questions for people in domestic cases. I know you wrote a whole book to help.
Did you read it?
I've looked at it, actually. I did. I actually purchased it.
Oh, you did? Oh,
I did.
Shit, no. I thought you borrowed one.
Well, no. If I'm going to come and speak to people,
do some research first.
If I'm going to come speak to
What do you
people,
think?
I think it's an important resource. I mean, I think that self-represented pro bono litigants in the family court system, it's an overwhelming and emotional and intimidating process.
Very intimidating.
Yeah, no. And for those of us, listen, I'm in a courtroom virtually every day, sometimes all day for 10 years. And so for those of us that do that, it becomes second nature. And, that is just not the experience of your average person. And I think sometimes we forget that your average person coming to family court, probably for the first time, first of all, they're probably there because it's one of the worst days of their lives. Something has happened in their family that is super upsetting and traumatic, and they find themselves in family court. And then they find themselves in the midst of a process that is confusing and intimidating. And so I think anything you can do as a judge to help people understand the process, slow down the process a little bit so they have an understanding of what's happening. I also think you convey it also through your demeanor and your tone with people. I think how you treat people in the courtroom.
Don't call people psycho and say you're going to take their kids.
For example, right? I think there's a real...
A judge has said that.
I think it's really important. It's really important to treat people with dignity and respect. I think that's really important.
Okay. So how do you plan to hold attorneys and CPS accountable for misconduct or misrepresentations in your courtroom?
Well, so for attorneys,
You think they could be vexatious as well?
And how many motions would they have to file? How many things would they have to file in order for you to say, you know what? Yes, this person is a vexatious litigant.
So a vexatious litigant, there's a specific legal definition that goes along. It is not just filing multiple motions. People have the right to file multiple motions. If they believe they have issues and they want to bring it back to court and bring the court's attention to it, they have the right to do that. That is not by itself a vexatious litigant. It becomes vexatious, I think under the statute and the case law, if it's intended to harass, if it's intended solely for the purposes.
I think some attorneys should be held in that.
Mm-hmm.
Although one would say, well, I'm not part of this case. I'm just getting paid to be here. But isn't it more valuable if it's a parent? I mean, they have something to actually lose, their kids. I can see a parent filing, but an attorney, I just can't. And some attorneys will do that too harass?
I mean, it depends. It's a very case specific thing, I think, right? You need to know what's going on in the particular case. What are the issues that are being raised? Does it graduate from, just multiple motions that are bringing up multiple issues to being vexatious? I think that's pretty case specific.
So the misrepresentation of CPS workers and attorneys, how would you handle that? The misconduct. How would you handle that in your courtroom if you found them to have done some type of misconduct or misrepresented the court?
Yeah. So I mean, I think that goes beyond just a question of CPS. If there's any witness who's not being credible or reliable with the court, that's an issue. And you take that into consideration whenever you're making a determination in a case. I think one of the most important things that judges do is assess the credibility of the people in their courtroom, and you factor that into the decisions that you're making. So credibility can come from, are there inconsistencies in testimony? Are there inconsistencies in what they're saying? It can be conveyed in a witness's demeanor. That's why I think being in court is really important. We now have the opportunity for audiovisual, and I think that's really good in certain circumstances. But if you're doing a trial, I think it's really important for the witnesses to be in court. The judge needs to see people testify. And so you're going to take that into consideration when you're rendering a decision in a case, for sure.
Are you automatically, because, CPS worker, they you would think that they are being truthful. You would think that they know their job, they know what they're doing, what they're presenting to the court, because they're in court, fairly often. We have seen some horrific things from one CPS caseworker in particular, but would that be something that you would just say to yourself, more so you would trust this person? You think they're telling the truth just because they're working for CPS or DCFS or any of those agencies, Child Haven?
I think that when you're a judge, it's really important to independently assess the credibility of every single witness that comes in front of you. And so I don't think you can say, oh, I'm going to give extra weight or extra credibility to the, whatever the witness is solely by virtue, for example, of their place of employment. You have to look at all of the facts in the case. You have to really critically discern all of the facts in the case. Are there any inconsistencies? Are there anything else that needs to be considered? You need to look at the credibility of every single witness, right? So it may be a lay witness, it may be a parent, it may be a CPS worker. And I think the court needs to be fair and impartial, bring the same level of discerning credibility to every single person that comes in the courtroom.
What would be, a lot of family court judges have to terminate parental rights for various reasons. What is that threshold for you where you would finally terminate their rights?
So there's a specific set of law, statutory section 128 that applies to termination of parental rights. I will say this, when a case comes into the child welfare system, termination of parental rights, as it should be, is really the last resort that you get to only if you have not been able to work really hard and reunify that family. And so one of the things that I think is very important with child welfare cases is being able to, as quickly as possible, get those parents into services. Sometimes it takes a while. It can take too long for the case to process on the front end. And can be for a variety of reasons. It can be discovery reasons. It can be complicated, medical evidence, for example, availability of witnesses, court docket, and scheduling, et cetera, et cetera. It's really important, and I work hard currently in my role as a DA to try to get those cases to adjudication and case plan as quickly as possible so that families have the maximum amount of time possible to engage in services. So if a child can be safely reunified, we're going to do it more quickly. If you go through that whole process and unfortunately a parent is unable to successfully engage in those services and you get to the point of termination of parental rights, typically that happens 18 months-ish into a case. At the 12-month mark in a child welfare case, the court has to make a determination around the permanency goal, and that's the point at which it might switch from reunification to something else. However, the court can also make what's called a finding of compelling reasons. And so if you have a parent who at that point is well engaged in services, working, and you have some level of confidence that they're going to get there, the court can say, I'm making a finding of compelling reasons to keep it reunification. If you get 18 months, 2 years into a case and you get to the point of termination of parental rights, the law says there's a number of factors that the court can consider in terms of unfitness. There's two big things the court has to consider. Number one is unfitness, meaning is there some factor that despite best efforts and despite efforts to get services in, there's really still a safety risk for this child that the court can't successfully address. And there has to be a finding of best interests, meaning what is the alternative for the child and is that really in the child's best interests? So it's a really weighty decision. There's a lot of gravity to that decision. There needs to be a really careful review of the entire record, the services that were offered to the parent, what they were able to engage with, and why they were or were not successful, what the risks are to the child, and also what is the alternative for the child. But termination of parental rights is a really weighty decision for a court. I think it's one of the most, probably the most on the family bench, at least in dependency decisions that judges make.
I like to piggyback on that, and I was trying to get some law passed a few years back, asking for a tribunal or a jury trial when it came. In fact, there's no jury boxes in family court, which I thought that was unconstitutional myself. But
there should be.
Asking for a tribunal or a jury trial when it comes to relocation and termination of parental rights, because that's a big deal. I mean, that means you lose your kids forever. So I never thought that one person should have that much power to tell a parent you will never, ever see your child again. Because you don't know what that one person probably has some type of bias or whatever, because not everybody thinks alike sitting on the bench and wearing that robe. They all think independently differently. Even when they look at laws, this is my discretion, this is how I read it, this is how I interpret it. And you ask the other judge, well, this is how I read it, this is how I interpret it. So what do you think about that? A tribunal or jury box for relocation of children? I'm not talking about relocating them from Summerlin to Red Rock, to the lakes. I'm talking about relocating them out of the country and terminating their parental rights. Do you think one person should have that much power to make that decision?
Well, I guess my first response is it's not up to me. It's up to the people of the state of Nevada, right? And the Supreme Court. And so, well, I do think it's important to say, and it kind of goes along with some of the other questions you've asked. As a judge, you don't get to just impose your personal opinion on situations,
But
right?
they'll use
Well,
their
you're not a
discretion.
judge yet, so you can have an opinion still.
That's right. We have no record of you.
Well,
I mean, they use their discretion. I hear that a lot. It's discretion. I use my discretion. And I think some of that discretion should be taken away, my personal opinion. I mean, follow the law as it's written. Don't go up the stairs. Oh, you could go up the stairs if you had a glass of water in your hand. You know, it says don't go up the stairs. Don't go up the stairs.
I mean, to your question on should there be a tribunal or should there be jury trials, I think that judges can make fair decisions.
All of them, every single judge you appeared in front of all these years have made a fair decision that you said, "Oh my God, that is so good."
Well, I can speak for I can speak for myself. I can speak for myself, right? And I do think that judges can make fair decisions. I think, you know, this goes to part of what you guys are doing here, the importance of having really experienced, really thoughtful, really ethical people on the bench who know the law and are going to apply the law.
Fair,
Yep.
impartial,
Yep.
Temperament,
Mm-hmm.
all that.
Mm-hmm.
Don't be sarcastic
No,
to litigants.
no.
You have, I don't know that I've met another judge or we've interviewed another judge with your particular educational background and all of that. So I see how that is very helpful to you, having that psychology behind not only for the children, but parents and what people are going through. I've not heard anyone with that background. I think that's great.
Thank you. I am also not aware of any other JD PhDs. Certainly not in Clark. And as I said, it's a background that I use every day, both like the knowledge part of having had that as my educational background, but also just the human part of it. You know, having a lot of experience working directly as a clinician and a therapist with people going through all of these systems. To me, understanding the human side of it is really important. I have patients from, 12 years ago, 15 years ago, that when issues come up I can remember back working with people who experienced it.
Some of these case plans, they all have therapy. They all have to go do these plans and therapy for months and all of this. And some parents are told you need anger management classes. These parents, you have a set of innocent parents that were accused, but these parents they're fighting for their kids. They're going to be angry because the system has their kids. But no, you need more therapy because you are angry. Well, that's any parent's response to wanting their kids back, especially when they're innocent. So how do you see that when you have a situation like that and these parents are forced to go months and months and months more for something like that when they're just fighting for their kids? They just want their kids back.
So under the law, in terms of case plan services, there has to be a factual basis from the original removal, the issues that led to the original removal for the services that are put in the case plan. A judge thereafter, if some new factual basis arises, can make a determination that there should be some additional service. But it has to really be tied to the factors that brought the case in that may have made the child unsafe, so that you're focusing services specifically on that. And then when you're looking at a parent who's in therapy and working with ongoing therapy, the input of the clinician or therapist that's working with that parent is really important and can help influence the determinations that the court is making. But I agree with you in the sense that I think for a lot of parents and a lot of families, the process itself is highly emotionally charged, and I understand that. And I think what the court really needs to be doing is looking at the parent and looking at the parent's progress with respect to the safety of their child and making determinations based on that.
How do you define justice in the context of family court? What's your definition of that?
It's an interesting question and an important question. I think justice is applying the law ethically and consistently to reach the appropriate determination in cases in the best interests of the child, but also considering the rights and the constitutional rights of the other parties involved. I think justice and people feeling like they have access to justice, right, is part of it. Also goes along with how the judge runs their courtroom, how the judge conducts hearings, how the judge treats parties in their courtroom. I think it's important to people, and I understand why, that even if you're in a highly charged emotional situation, even where, ultimately the court may not be making a decision in your favor, feeling that you were heard, that you had the opportunity to make your best argument, and that you were treated respectfully is important in terms of, the public feeling like they have access to justice in family court.
So family court is very emotionally charged, and I think a lot of judges bring their own personal bias onto the bench when they're imposing their discretion. So I'm gonna ask you this question. How would you handle cases where the law conflicts with what you personally believe in is the moral right outcome?
Those are going to be your toughest situations as a judge. As I said earlier, however, judges apply the law, and judges have to apply the law that the people have enacted through their legislature.
What happens if they put their discretion in there, which a lot of family court judges do?
I think you have to be judicious with the exercise of discretion. I don't think, exercising judicial discretion doesn't mean deviating from, the law that applies. So to me, that would be, the law would be my North Star.
And this is going to be my last question because I could go another 2 hours with you. What qualities do you believe are most essential for a fair and effective family court judge?
Experience, knowledge, compassion, ethics, diligence, and work ethic. Being a judge, if you're, is a hard job. It's going to be a high volume job, and every single case that comes in front of you, you got to give the same attention and care to. If you've got 25 cases on the docket, you got 25 cases on the docket, but there's a child and family at the center of every single one of those cases.
Okay. Ms. Phillips, have any more?
No, we'll have to have her.
Gwyneth Smith.
Gwyneth Smith.
Gwyneth Smith.
We'll have to have her back on the show after January.
Yeah.
But thanks for coming on.
Yeah,
Yes.
We appreciate it.
Thank you for having me. I appreciate it.
Mark is going to zoom in on you, and you could say whatever. Go to my website, vote for me, hey, whatever you want to do.
So first, just thank you to both of you for having me on the show, giving me the opportunity. My name is Gwynneth Smith. I will be running for family court in January, Department D. As I said earlier in this interview, I think family court, the cases that come before family court judges are some of the most important in our community. It's our opportunity as a community to try and intervene positively with kids and families, and that can make a difference that lasts a lifetime. So I just think it's incredibly important to have the best, most experienced people we can on the bench. I feel like I can make a difference, and so I feel compelled to put my name forward. So thank you.
Well, thank you so much for being on the program.
Thanks.
Thank you, Ms. Phillips. Folks, that's Gwynneth Smith. She's a candidate for Clark County District Court, Family Division, Department D. And Department D has Robert Tootin. He's been there for many, many years. I've known him for all the years he's been sitting on the bench. And he runs a tight ship over there in family court, and now he's retiring. And Ms. Smith wants to fill that position. And I think it's very important if you're going to fill a position for a juvenile department, is the one she's looking at, that a psychology background. I think all the judges of family court should have a psychology background, but especially when you're directly dealing with the juvenile population, I think a psychology background is very essential. And I hope that this program has been educated and beneficial for you, and for you to know this candidate could one day become your next judge, January 2027, right? So really pay attention to these candidates. It might be a crowded field in Department D, or she might be the only one there. Who knows? But this is Steve Sanson and Stephanie Phillips with Veterans in Politics. Until next time.